The legalities surrounding surveillance is a major topic of discussion today, and that is exactly what we will be discussing in this video. The goal of this video is to equip aspiring private investigators with the essential knowledge they need to navigate all the ethical and legal boundaries while conducting surveillance operations. So let's get started. Let's first look at the evolution of surveillance and surveillance laws as we know it today. Private detectives first emerged back in what we will call the early days, the 19th to 20th centuries. The first PIs back in the 19th century were often former law enforcement officers or military personnel who had some special training and a knack for uncovering the truth and who offered those services for hire. Now, following someone back then was a serious physical task, to be sure. Private investigators relied on observation skills and disguises as they mostly followed their subjects on foot and usually into close quarters areas, and they needed to be able to follow their subjects without being detected. There were no special technological tools for these early PIs to use either. There were no cameras, GPS tracking devices, or other surveillance tools. Moving into the mid-20th century, some of those technological wonders started to emerge in the fast-paced and quickly changing world of private investigations. Cameras, for instance, were becoming more common for PIs to use. This allowed them to document their observations. This photographic documentation worked very well for them as it allowed irrefutable proof in many cases. The use of cameras also allowed them to follow at a greater distance, but then it also created more risk for the PI as everyone around them might see them taking photographs of their subject. This video is sponsored by OREP Insurance and Working PI Magazine. OREP is a leading provider of private investigator liability insurance. Visit orep.org for a quote today. Lighting, of course, would have been a huge challenge back in those days too, as there were no cameras with low light, low lux, or night vision, and using a flash would most likely tip off their subject instantly. With the advent of film or video cameras, private investigators were now able to step up their game and not just grab that moment in a photograph, but grab the money shot in a fully engulfed video to show the client what was truly transpiring. But then shortly after the use of still cameras and video cameras, the questions of authenticity and ethics started creeping into the picture. Now, don't get me wrong, prior to the ability to get photographic evidence, there were many challenges to a private investigator's findings. Much like today, it was very easy for the subject of an investigation to refute the facts and for the subject to try to disqualify the PI in a he said, she said battle. And those challenges are even more relevant today, as it is easy with all of the technology, software, and AI to change photographic and video evidence. There was an era back in the old days, long before my days as a PI, where private investigators did use some rather invasive means to gather evidence too. For instance, wiretapping after phones became popular. This was technology used by governments, but many PIs, who were often former law enforcement, began practicing this method of surveillance too. And in order to do that, well, they needed to be able to get into secured places beyond those locked doors and windows. And lock picking was a big tool for private detectives back in those days too. It seemed like there was not much a PI wouldn't or couldn't do for that matter. You see, back then, the laws regarding surveillance were lax, or dare I say, non-existent, leading to few restrictions on who could conduct surveillance and how they could conduct surveillance. As we move into the late 20th century, we started seeing more advanced surveillance technology. The development of two-way radios, for instance, enhanced multi-operative surveillance immensely. Prior to having two-way radios, the investigators just had to have a plan of who did what and who would do what, all based on possible scenarios. I imagine there were probably some hand signs that they used in order to quickly convey information back and forth. But for the most part, it was everyone sticking to the script and knowing what each investigator was responsible for doing. With two-way radios, walkie-talkies, and now cell phones, there is the ability for constant contact on the surveillance team and the ability to adjust tactics on the fly as the surveillance progresses. Then GPS tracking devices came along. Now that seemed to be the answer to every private investigator's dream. This technology meant the PI could track and follow their subject with little to no threat of being noticed. But as they say, all good things must come to an end, or at least come with limitations, to be sure. You see, during the evolution of private investigations industries and the increase of technology available, it became apparent that laws would need to be put in place to guarantee an individual's rights to privacy and ensure legal and moral boundaries remained in place. The Wiretapping Act, also known as the Omnibus Crime Control and Safe Streets Act, was enacted back in October of 1968. But even before then, there was the Title III of the Civil Rights Act of 1964. This law prohibited the use of wiretaps for domestic purposes without a court order, but it did not specifically regulate private investigators. But before that, there was what is often referred to as the Wiretap Act of 1938. This is in reference to a provision within the Communications Act of 1934. This was, for all intents and purposes, the first federal wiretapping law passed by Congress. It outlawed wiretapping as a federal crime and declared that evidence obtained through wiretapping was inadmissible in court. More broadly, though, the Wiretap Act is more commonly associated with Title III of the Omnibus Crime Control and Safe Streets Act of 1968. It addressed concerns about government agencies and private individuals conducting extensive wiretapping without the parties' consent or legal authorization. The 1968 Act, also known as Title III, prohibits the unauthorized, non-consensual interception of wire and oral communications by both government agencies and private parties. It also established procedures for law enforcement to obtain warrants for wiretapping, and it regulated the use and disclosure of communications intercepted under proper authorization. Now keep in mind that laws regarding wiretapping and other forms of surveillance can vary across different jurisdictions. So it is essential for private investigators to familiarize themselves with local laws and regulations as well as federal laws and regulations. Assuming that you are not trying to tap a phone or put surveillance software on a phone, which would be considered a tap pretty much in today's world, the main area where these laws fall into play for today's surveillance investigators is in regard to recording somebody. Most states, but not all to be sure, have what is called one-party rule to recording conversations. And this generally applies to conversations where all parties are in person as well over the phone or on a Zoom call or wherever. But there are caveats to this as well. For the most part, though, if the state you are in is a one-party state, then only one person who is part of the conversation needs to know that the conversation is being recorded. So if you are a party to the conversation, in other words, you are conversing with the other person or persons, not just listening in on the conversation, then it is okay to record that conversation. But many states are two-party states, meaning that at least two parties to the conversation must be aware that it is being recorded. So if it is just you and one other person talking, you and the other person must be aware it is being recorded. But if it is a group of 3 or more people, well, only 2 people need to know the conversation is being recorded. Then there are the states that are referred to as all-party states. In these states, everyone involved in the conversation must be aware that the conversation is being recorded. Now keep this in mind too. This applies only to audio recordings of the conversation, not video recordings. When it comes to video recordings, well, it gets a little trickier and more complicated. Again, you need to know what your state allows and does not allow, but generally speaking, anything, anybody, any activity within public view can be videotaped or recorded. Now, I always recommend for PIs doing surveillance to always have their microphone on their camera turned off so they do not inadvertently record other people's conversations situations that they are not a party to. Now let's quickly discuss the big white elephant in the room, the GPS trackers and the use of those in surveillance. Can a private investigator legally use a GPS tracker to track someone? Well, it all depends. Just like everything else, there are varying laws from state to state that may regulate the use of these surveillance devices. But even if there are no laws, well, there may be other laws that are just as effective or even more effective in deterring PIs from using GPS or other tracking devices. Take Colorado, for instance. Here in Colorado, there are no laws regarding the use of GPS tracking devices. In fact, Colorado doesn't even have PI licensing regulating the private investigations industry. But there were several cases some years back that set some legal precedents in using GPS tracking devices by PIs. Those cases involved domestic situations where one party of the relationship hired a PI to surveil the other party in the relationship, and the PI used a GPS tracker to assist them during the surveillance. In those cases, the PI and the client were both arrested for stalking and harassment. Did you hear that? The PI and the client were both arrested for stalking and harassment. Now, they pled the charges down to harassment, but the damage was already done. The harassment charges alone were enough to allow a better settlement for the other side, not to mention those PIs never worked as PIs again after that. Other areas where PIs need to be vigilant in their efforts to ensure their activities are above board, legal, and ethical is to make sure they are never using, nor their clients are not using, any form of digital surveillance. What I am talking about are things like specialized software apps that allow monitoring computer activity, email accounts, and online activities. The use of these things goes a long way into violating a person's right to privacy, as well could well violate federal wiretapping laws as they pertain to technology today. And when you are gathering video evidence, keep in mind what you can and can't gather video of. You can't just stick a camera up over a privacy fence or shoot through a knothole or a gap in fence boards. The people behind that privacy fence have a reasonable expectation of privacy. That reasonable expectation of privacy generally expands into other places like bathrooms, workout gyms, and other locations. For instance, in most, if not all states, you cannot shoot video of activity inside a residence through a window, even if it is in plain public view. Drones, for the most part, should be avoided like the plague when it comes to surveillance too, in my humble opinion. Using drones exposes so much risk to private investigators, as they risk violating privacy rights, and many other laws could be broken regarding flying the drone and other local and state laws. The big takeaway is this: if it doesn't feel right, it probably isn't right. If you are not sure if you should be doing it, then you probably should not be doing it. And the big question I always ask myself is, how will this look above the fold if things go wrong?